And then, as much time as you need, and then of course, there's more details in there in a different section. If you
Good morning. Apologize for my lateness. Things going on this morning. We fix this, and I'll be right back. God bless. Thank you. Appreciate you for being here. I got to fix this banner. Thank you.
Yes, sir.
Okay. All right. If you would, does that refresh your recollection as to what was, how many tasers were collected?
Yes,
How many?
there were two.
Okay. And ultimately, did you draw conclusions about whose tasers you had collected, CO-wise?
I do know, yeah, because the jail administrator advises who they belong to.
Right. And you also have reviewed the video a number of times, and you can kind of start to put that together, correct?
Yes.
And you've also reviewed same statements that Dr. Mitchell reviewed, right?
Yes.
Okay. Of the COs, right? Okay. And so let's speak first. Officer Longshore, you collected his taser, right?
Yes.
All right. Tell us what the results of your investigation were into the deployment of Officer Longshore's.
Let's see here. Make sure I get the right. You said Longshore, correct?
Yes, sir.
Particular weapon was used 4 times during the altercation with Rios, according to the weapons downloaded report. 3 of the deployments were for 5 seconds, and a single one deployment was for 1 second.
Okay.
For a total of deployment time of 19 seconds.
Deployment time of 19 seconds. What does that mean to you?
Just that the device is cycling.
Okay. And it's, in other words, in order for the device to cycle, what mechanically does the user have to do?
Normally you have to pull a trigger.
Okay. So just like a gun, a taser is held on a handle and there's a trigger that's available for your trigger finger. Is that
Yes.
accurate? You aim the taser at your intended target if you're going to use the barbs and prongs deployment, right?
Right.
And then fire with the idea that the prongs will hit the individual and become affixed in them somehow, correct?
Correct.
Now there's a conducted energy that allows for the juice or the jolt to happen, right?
Yes.
And that juice, that jolting continues until the individual who's deploying the taser pulls off the trigger?
No,
Please stop.
I'm not an expert with tasers.
Do best you can.
It's been 18 years since I've used or had the ability to use one, I guess. They're set at 5 second.
Okay.
I call them cycles, but they're set at 5 second intervals. So they will, from when they're initiated with the trigger pull, they will run 5 seconds if you do not stop it.
Disengage.
Yes.
And is that why, in your opinion, there's 3 5-second and one that is just 1 second?
Yes.
All right. And it stands to reason that there would be this like 5-second limit to keep someone from tasing someone indefinitely.
Yes.
Right. Okay. All right. Now, it was this taser that we could see on the video that your investigation confirms that Officer Cooper was struck with in the webbing of his hand, correct?
Yes. Well, I would have to assume that because of the cycle times.
Okay.
I do recall that if I recall the video correctly, the first deployment that actually had the cartridge in it with the bay doors, it did cycle through, I believe, for the 5 seconds.
And that happens based on your review of the video and all the evidence of the case. That happens just as soon as Officer Cooper enters the struggle, right?
Yes.
Okay. In other words, it's all already underway by the time Officer Cooper responds, correct?
Yes.
The first thing that happens to Officer Cooper is the taser's deployed and he gets hit in the hand, right?
Yes.
And I think your question about this, he walks away, seemed kind of pulling at the wire, right?
Right.
Okay. You know from your investigation that Officer Cooper went to the hospital after this, had his hand looked at? That,
Yes.
yep.
Well, I was made aware of that, yes.
Well, you've reviewed all the statements and all the evidence in the case, right?
Yes.
And people talk about it at all, and that's in those statements, right?
Correct.
Been tased as part of your training, ever?
It's been a long time ago.
Right. But that has happened to you?
Yes.
Describe it as something that is painful,
Sure.
something that can have some lasting effect,
On your memory, yes.
right? The prong itself, were you tased where the prong was stuck in you?
I believe it, yeah, it was several.
Or was it a
Right
drive
hand.
tase?
It was,
Dry
no,
slip.
he had a barb in his hand.
What about you when you were tased?
Oh, no, we used alligator, it was a makeshift, alligator clips on the back of it. Those are expensive, so in order not to keep buying for training, they have a separate device that, it clips on your shirt.
Right. It's also makes it so you don't have to be fishing the probe out of the person, right?
Yeah.
Okay. With respect to Officer Prendergast, his taser, what can you tell us about that? When watching the video, we can see that Officer Prendergast kind of removes his cartridge, right? Do you recall that?
Yeah, there was a cartridge laying there. It did look like the bay doors didn't appear to be removed from that one. This particular weapon was used one time during their altercation with Rios. Single deployment lasted for 1 second.
Okay. All right. And so what is the difference between a dry stun or dry stun, I've heard it described both ways, and the deployment that involves the bars or the cartridge?
What's the difference?
How's it work?
So
Talk about how it
Excuse
works.
me, Your Honor.
Yep.
Can we clarify whether this is based on Special Agent Lehnhart's experience? He's already testified he's not an expert on tasers.
It'd have to be based on your training experience with tasers.
Do you have familiarity with what dry stun mode is?
yes,
I'm not asking for an expert.
Okay. Yeah, I'm okay with it as long as he's talking about what he knows
Sure.
as being a law enforcement officer. But I don't want him talking about giving opinions that would require him to have some information or education beyond his experience working for BCI and his prior law enforcement experience.
Your Honor, for purposes of the record, the question that was originally asked was, what's the difference between these two types of use of the taser? I believe that calls for a level of experience in an opinion that goes well beyond Special Agent Lehnhart's
I guess I just
level of
disagree
knowledge.
with that.
I guess, I think he can talk about it based on if he's trained with him, if he's been tased before as part of his training, if he ever had one. So I think you can get some foundational questions to help us out, but I think if he can do it that way, I'll allow it, but I think he needs more foundation.
Based on your experience with the Mansfield Police Department and as a special agent, do you have familiarity with the use of tasers?
yes,
Okay. And do you have some degree of training with respect to the use of tasers?
yes,
Okay. Do you have familiarity with I guess, essentially two different methods or manners by which you, as a law enforcement officer, can deploy your taser?
yes,
We talked about method number one about 5 minutes ago with respect to aiming and shooting the prongs into someone and then conducting the electricity through wires, right?
sure,
Is that one method?
yes,
The other method that I was starting to ask you about is the so-called dry stun method. Are you familiar with that based on your training and experience?
yes.
Can you tell us what that is?
That's when when the cartridge in the taser is removed, the connectivity points that actually trigger the bay doors and the cartridge that shoots the prongs, that will also conduct the electrical current. So without the cartridge and with the prong shooting out of it, you can actually place it on skin and activate it and get a an electrical response out of the unit in that form and fashion. So where the first method that you had asked me about is a distance. So if you have a distance between you when it's deployed, as opposed to when you're close, those taser barbs are not going to deploy properly if the cartridge is still in the taser and you're holding it up to somebody's skin.
Okay, so it's an alternative use
Yes,
to bring about essentially the same type of result, right?
yes,
All right, and it's essentially what amounts to either method is a pain compliance is a use of like electricity to gain compliance through a pain technique. Pain, I can't think of the word that I'm looking for.
yes.
Okay.
Pain compliance?
Yes, right, okay. The idea being people don't like being tased, so whatever they're doing, they'll stop doing it so that they can be gotten under control, correct?
You hope.
You hope? Yes. Now, with respect to video, book-in room isn't the only area in the jail that has these types of cameras, right? Meaning security cameras.
The rest, I believe the whole jail does, yeah.
Right. And so the eye in the sky, if it were, is kind of following you all throughout the jail during your stay if you're an inmate, correct?
Yes,
Okay. That includes when you're brought into the jail during the book-in process, you know that the Richland County Jail has a body scanner, correct?
that I was not aware of.
Not aware.
No,
Do you know what a body scanner is generally as an investigator with the Bureau of Criminal Investigation and Identification? In the jail setting, generally speaking.
in the jail setting, no. I'm not familiar with those scanners.
Would it surprise you to know that they have that kind of equipment in a jail so that they can run people through it, get a look at what's inside of them, imaging?
Your Honor, accept. I'm going to object again. Now, Mr. Mayor is testifying because this witness has already said he has no familiarity with that machine.
Yeah, I don't think he knows, so, I was sustained as far as his knowledge. He doesn't know what they are. He may know that they exist, but he doesn't know what they do, so I'll sustain.
Did you make any inquiries in this case at the jail, whether with the administration, sheriff, or any of the people that you spoke with as to whether there was any technology in the jail that they're run through inmates to make sure they're not bringing contraband into the jail? Did you make an inquiry into that?
Advanced technology like that, no.
May I approach?
Yes.
Agent Lehnhart, I'm going to show you what's been marked as Defendant's Exhibit F. If I were to play this, it would be one of these body scan videos showing Alexander Rios heading through the body scanner and the time leading up to that.
Okay.
Have you had an opportunity to review that now that you
No,
know?
this video was not this video was not provided to me when the rest of the videos were given to me.
And so what you're telling us is that Alexander Rios being booked into the jail, going through the body scanner, is not something that you've ever had an opportunity to look at
I have
as part of
not.
your investigation.
I'm not.
You know that there's been discussion about drugs in this case, right?
Sure.
Whether or not he was under the influence of drugs or not, right? You know that generally speaking, drugs in jails are problematic, right?
Sure.
And so it would be important to your investigation to take a look at that type of evidence to see if there was anything concerning or suspicious regarding Alex Rios's process of going through that scanner. That would be relevant, right?
Yes.
Something you'd like to see as part of your investigation?
Sure.
Would you like to take a look at it right now?
Yeah.
Approach.
Dan DeRose with 19 News. As the judge wants to speak with the attorneys, it certainly appears that the defense for the second time in this trial, is about to announce new video that has not been previously seen. On the stand is an investigator with BCI, that's the Bureau of Criminal Investigations, who was basically overseeing this entire process and the investigation into the death of Alex Rios. So the fact that we're about to see video that the lead investigator himself has never seen is very intriguing. And the video that he wants to show, apparently, is in the booking process of Alex Rios. Earlier, we saw the testimony, as we see there, the man standing trial here, that is former corrections officer Mark Cooper. The reason he wants to show this is it goes back to that piece of plastic evidence that was taken out during an autopsy of Alex Rios, and exactly what was in that piece of plastic. We heard the defense already start to poke holes. Remember, that's all the defense's job, is to create doubt in the minds of the jury. Remember, guilty beyond a reasonable doubt. And if they never tested that piece of plastic, and it's the defense's contention that that was full of methamphetamine that Alex Rios swallowed so that he wouldn't be caught with it. Now, we heard him on this exploratory questioning of the BCI agent. Did you ever test that? No. Have you seen the booking photo to see if he did anything suspicious? Now, if this defense starts to play a video of the booking process, so the first time Alex Rios is brought in handcuffs, if they somehow have a video of him taking a plastic bag and swallowing it, and it's caught on camera, that would go a long way in the mind of a jury that this idea of the excited euphoria, let me get the exact term, that they think he died from, go back one more page here, excited delirium.
Switch it up.
This notion that you can die if you have drugs in your system and you get to this excited state. If we see video
They're so
of
out of
Alex
control
Rios
with it,
in the
it's
booking,
ridiculous.
throw a piece
Come
of
on
plastic
now.
bag in his
He was
mouth, that is
obviously
going to
high.
go a long way. We can see the defense here debating. He has two lawyers. Mark Cooper has two attorneys. Both those
Of
gentlemen
course
there.
he does. He needs them.
And so it will be interesting to see if the judge will allow them to play this video or not. I can't see where the argument would be
The interesting
of
thing.
why the judge wouldn't allow this video from the booking center.
So you've mentioned several times the prosecution team in this case during your cross-examination this morning, correct?
Yes.
And you're essentially working alongside the prosecution team in this case, right? You're sitting at their table.
Yes.
Okay. And so you are familiar with the information that the prosecution team has put together in this case, whether it's what you provided or has come to them, correct?
I know some of it, I don't know all of it.
All right. And so what you're telling us this morning is that when I approached you with the exhibit, with the purpose of asking you questions about it, an exhibit that purports to be the body scan process at the jail of Alex Rios, you're indicating not only have you've never seen it, right?
I've not seen that.
You're also 100% unaware that it was a part of the prosecution's team evidence or what they have in their possession.
I don't recall I don't recall seeing that video of his booking. I recall the written documentation of when he was brought in. There's like written reports or the checklists that the COs do, but I do not recall seeing a video of any scanning devices.
All right. But you would agree on the issue of drugs or not drugs in the jail, that process would be pretty important to take a look at in your investigation.
If that process detects drugs in the scanner, yes.
Or if there's any movements going on that would be suggestive.
Again.
Objection.
All right, I'll move on.
Okay.
All right. Did you make any efforts to obtain video during the 8, 10, 12 hours that Mr. Rios was in the pod setting, the general population area, before being moved down to suicide watch?
No, because once again, our involvement was, obviously 10 days later. and he was already down into the booking area at that time. So no.
Okay, so I just want to be clear. What I'm asking is, you did obtain video from the booking area, obviously.
Yes.
And that was 10 days after the event that it came into your possession, correct?
Yes.
Did you make any effort to obtain video from the time that he spent in the pod prior to being transferred down to the booking area?
No.
Have one moment, Judge.
Yes.
So there was clearly a problem with this idea of wanting to show the body scan portion of the booking process, that the judge did not allow it. My guess, and of course this is just a guess because weren't privy to the conversation between the judge and the attorney, is that there is, and you heard him, there was an objection when the defense attorney said the process of...
I appreciate you answering my questions so far this morning. That's all I have at this point. Thank you.
Redirect Assistant Prosecutor Salisbury.
Yes, thank you, Judge.
As we get a redirect now from the prosecution, my guess is that he was going to try and imply that there was some movement or, maybe nothing that was definitive of Alex Rios swallowing anything. And of course, in a court of law, you cannot imply or infer anything. It must be concrete.
Observed the urine and or blood that was obtained at the hospital from Alexander Rios.
I'm sorry, can you?
Well, did you have knowledge that by the time you got involved that those samples were gone?
Yes.
Okay. And is that the reason why you didn't do anything further? There was nothing to do because they didn't exist, right?
Right.
Okay. Would you have done that had they been available?
Well, yeah, you always like to try to get that stuff because that's kind of a key piece.
Okay. And
And if I may, each hospital system is different on their lengths and time. So,
sure.
yeah,
Okay. And in this case, you knew they were gone.
yes.
Simply put. Okay. The item states exhibit number 7 or whatever it was, the thing that was removed from Mr. Rios' stomach. Tell us the reason why you didn't request that that be tested for drugs.
So when Agent Rodriguez and I had met at Office 71 there in Delaware, Sunbury, he had indicated to me, and actually I believe the sticker on the outside of it also said removed from the gastric contents. Mm-hmm. And so relatively speaking, I guess, even though Mr. Rios was in the hospital, we know Mr. Rios was in the hospital for 10 days.
Objection and ask to approach.
Yeah.
For 7.
And again, we're going to get another sidebar discussion between the judge and the attorneys. There have been a lot of these in this trial, an inordinate amount of sidebar issues because of, and I think this only helps former corrections officer Mark Cooper. There are a number of items that even from, I'm not an expert, the fact that that piece of plastic that was taken out of his stomach was never tested for any substance. Was that a baggie of methamphetamine? Did he ingest meth in a whole form at some point during that night that he was arrested, then the struggle, and could that, along with the struggle, the body full of methamphetamine, could that have led to the cause of death? The fact that it was never tested is kind of an issue. And
it's a major issue. And if that is even the case, they're trying to pull evidence in that isn't even isn't relevant at this point. At this point.
Is in the hospital on life support and then dies. It's only 3 days after that that the autopsy is performed, or 1, 2, or 3 days after. It's on that third day that this BCI detective is given that piece of plastic. And so he is trying to say the reason we didn't test it was because, well, it was 10 days later, and it would be speculation to say whether it would or would not come back positive for any methamphetamine. We also saw the defense poke a hole and ask, well, did you ask the hospital if they had kept any of his urine by the time you had gotten on this case? Because couldn't use the urine to see what levels, but again, it would have been 10 days later. But he said no, they did not ask the hospital. They were not given any urine from the hospital. They did not collect it. As you heard the detective say, every hospital system is different on how long they hang on to samples like that when someone has passed away. Again, all the defense trying to do here is poke some holes, put in some doubt into the mind of the jury. They didn't test the plastic baggie for meth or whatever that piece of plastic was. Interesting, I learned something today when the detective said he first picked up the sealed plastic bag that had that piece of plastic in it, that it started to bubble up and form gas within that sealed piece of plastic. I didn't know that that could happen. It looks like we're going to get back to our testimony now.
Talked about that 2 days ago.
And then if he offers that someone told him something, again, ladies and gentlemen, what somebody told him would be hearsay, so it's not admitted for that that's actually the truth, but it would be admitted to show why he either did or did not do something thereafter. So if you can answer those with those two stipulations, I'll allow it.
So Agent Lehnhart, again, I'll ask, why is it that you didn't request that that item be tested for drugs?
My training and experience as a law enforcement officer also allowed me the opportunity to become an advanced emergency medical technician in the state of Ohio. So I do have a little bit of knowledge about basic knowledge about human anatomy. This item sat in Mr. Rios' stomach. That's where it was taken out of, at least I have to believe that the doctors report. And there are acids. Our stomachs are very acidic. So after getting treatment for 7 days, it's more probable than not that the acids in the stomach degrading not only potentially the item that it came out, but also any substances that were on it would more likely than not been either inconclusive or negative.
Okay. You are, well, let me ask you, are you familiar with the use of force policy at the Richland County Jail?
Just from, yeah.
From here in this courtroom?
Yeah.
Right? Okay. That is a policy, not the law in the state of Ohio, is that correct?
I'm going to object to that.
Okay.
Ask your coach.
Yeah.
And here we go with another approach of the bench, an objection. The use of force by that particular county jail. We're talking about the Richland County Jail. Again, yet another objection. This case has been full of these objections and sidebars. It shows the complexity of the trial. And again, I think all of this works in the favor of the defendant, because all his team is trying to do is put doubt in the minds of jurors. And if the attorneys can't agree on what can and cannot be said on about an every 5 to 15 minute basis, that is very telling for a jury that, wow, there's so much at stake here. There are so many minutia, these little details here that need to be debated on such a continual basis that's what we're dealing with here. I'm going to give you a warning again that we're going to show just a clip of the video that's at stake here for former County Corrections Officer Mark Cooper. This is tough to watch because this is the restrainment of Alex Rios. Take a look here. You can see Rios's head is being pushed to the ground. He is still fighting, being cuffed.
I'm not showing that.
You see right there, the weight of Mr. Cooper is now standing on the back. He does it again. It's for a total of 7 seconds that he puts his full weight back there. Part of this trial, and you see then he kneels back.
I cannot, I will not allow that. I'm sorry. I'm not going to let him talk about that. They keep going over it and over it. It's wrong. It's wrong.
Results.
It's like they're enjoying showing it.
In that sheriff's department, and about how far to take this. That's why we constantly are hearing, and we heard from the first BCI agent that the first time he was called to get involved with this case was in the middle of the autopsy with Mr. Rios. He said he was a little taken back when he got to the autopsy, that the doctors and the coroners at that facility were a little confused as to why BCI was showing up to the autopsy, something that would normally be standard. Let's say we know that BCI is now required to handle all investigations where an officer uses their weapon, their gun, and shoots and kills a suspect. BCI is immediately called in and would be standing there for every second of that autopsy. So for the fact that BCI showed up in the middle of the autopsy, and they asked the detective, how did you know that the autopsy was underway? And he was a little hesitant to answer the question, and he said, they said, was it because his body had already been opened up? And he said yes, and that he was a little surprised at the fact that he was. It's not that he was late, it's that the autopsy had started right away. So there are a number of instances in this case that, and I'm not an attorney, I'm not an expert, but I sit through enough of these from the perspective of a juror, and that's what we always ask you to do at home. Put yourself in the shoes of the jury here. You get all these disruptions, you get all these arguments by the defense and the prosecution there, standing at the judge's desk there, the judge's bench, and then you have all these other factors. BCI was late to the autopsy, and not late, they were joining the autopsy in process. Nobody tested that piece of plastic, that baggie, and we just heard from the BCI detective who says he has a little bit of knowledge of anatomy, that 10 days later, the fact that testing a piece of plastic that had been in someone's stomach for that long would not result in anything.
Everybody back in 10 minutes. We'll continue to talk up here for a second.
And now we're going to get a 10-minute break because this discussion is continuing between the judge and the attorneys. This is really just one of those situations that is a little bit unprecedented, and the judge is going to make us turn our camera off here in a second, I believe, unless they go back on the record. They're clearly having the jury escorted out here, that they need to have a bigger discussion between the attorneys, the defense, and the prosecution. We'll see if they do that on the record. If they do, we will let you in on that. We'll let you watch. Some of these get pretty contentious when the jury is not in the room, and the attorneys can really let loose and try and make their argument one way or the other on whatever this issue is. And this issue is really surrounding Two things here: the baggie, why it was never tested, and why this BCI detective never asked the hospital for any kind of urine or any kind of sample that was taken from Rios in the 7 days that he was in the hospital. And as they continue that line of questioning, it's getting pretty contentious. Obviously, some objections made, and they're having to go on to a bigger discussion. We're still looking at shots of the ceiling here, which tells me that we may be losing this feed altogether. But in the meantime, let's listen to from Friday, our reporter covering the story.
I'm going to skip ahead.
The
We did
synopsis,
Friday.
because the other
Friday's
thing at
on
stake
here.
here.
I apologize. Here we go. Sorry.
Take it off! Taser! I'm not even fighting him!
I can't have that. Sorry. Nope. I had him mute the screen and everything because I'm not allowing this. I have too much respect for the family, for any child who could possibly be watching this. If you want to go see the video, go see the video. I can't do it. I won't do it. And it's pretty evident what happened. I don't understand why they have to continue to do this with the video. Jesus God. I'm glad you guys aren't listening to this right now. I wish I could cut it off. Cut it off for you guys. I can't cut it off for myself. It's horrible. We're almost at the end of this tape. I just wish they could come up with something more intuitive instead of just replaying a horrendous video. It's really uncalled for. I'm not here to exacerbate pain. Again, I apologize. I refuse. It's about to be over. I'm sure Dan DeRose will come back with something to say. Yep. Right on time. There he
that
is,
goes
being
without
the
saying,
Rios.
especially considering that it would be 7 days later that Rios would die in the hospital. There is a debate, as you would expect in a courtroom. You can get an expert, you can hire experts to testify on just about anything. I've covered enough trials that if you need an expert to say something is black, you can bring it in and they will say it's black. Then the other side will bring in another expert to say, no, that's white. So it is what happens.
Yeah, and I know a guy in South Philly, I can get inspection stickers on a tire.
Side what is true or not. You have two sides, one saying that this was excited delirium, that is in fact a term that's no longer used. Remember, this is back in 2019. This investigation has been lengthy, and it's really the family of Rios that has been fighting for this trial and for this day for some time.
And
you have Mr. Cooper, Mark Cooper, who was the bald corrections officer that was had his.
Sorry, I had to mute him for a second. Here's a fun fact. His brother, see these. Sorry. So, here's a fun fact. Rios' brother is in corrections. Just a little food for thought there. And he just keeps going on. They keep going on about this tape.
Was this excited delirium? Was this drugs in his system put into a heightened state, which then caused his death? Or are you going to believe the expert that was brought in to testify, a man who's watched the video and who reviewed the coroner's report? Let's remember, he in no way, shape, or form performed the autopsy. That's a big difference here. Generally, if a family believes very early on that something wrong has happened to their family members, some other cause of death, they can ask for their own private autopsy. Well, that wasn't the case here. You had the one done, which would have been somewhere between 8 to 10 days after Rios had died, and just a situation that we are in now here at the trial. Again, former corrections officer Mark Cooper being tried for manslaughter and reckless homicide.
Repeat and repeat. I don't understand what the point of him bringing up a toxicology report in the time of when it was done. I gotta wrap my head around that one. Do some research, because regardless, everybody knows that he was high. I mean, let's be real about it.
Death, that this was homicide, and I believe he uses the term asphyxiation. So let's look at Mike Mason's report from Friday evening.
Most of today consisted of testimony from Dr. Roger Mitchell. He's one of the world's leading experts in forensic pathology. The prosecutor thought he'd bring a lot of credibility to the case. Mitchell works with the CDC to help coroners around the world to verify whether the cause of death is accurate in their autopsy reports. He was called to testify about what he believes led to the death of Alex Rios. Former corrections officer Mark Cooper faces charges of manslaughter and reckless homicide in this case. He remained stoic while taking notes during the testimony. Mitchell had previously been asked to watch the videos of officers restraining Rios and review all of the evidence that was available to coroners when they wrote the report. Mitchell did not agree that the death was accidental or due to excited delirium.
I wouldn't have diagnosed him with a methamphetamine overdose because of what we saw in the video. That absolves any drug reaction from its effects on a human when you stand on their back until they can't move. The cause of death is asphyxia due to compression of torso and neck, complicating violent subdual and restraint by correction officers. I have his manner of death listed as homicide.
The defense attorney then tried turning the tables on Mitchell by showing him never-before-seen jail video of the incident. The defense didn't have much to say about that new video, only to point out that experts testifying for the prosecution hadn't seen it. Later this afternoon, the Richland County coroner took the stand. He's the last one who signed off on the death certificate. In the newsroom, Mike Mason, 19 News.
And we can now report that the jury has been sent to lunch. Add that as the next curious piece of this trial that has been really almost sort of discombobulated the whole way through. This is about as early as I've ever seen a jury sent to lunch at 10:50. They've only been hearing testimony for an hour and 50 minutes. So I think what we're going to do is we will take a break as well. Wait, I'm going to double check on this because I'm starting to see our shot come back up. Perhaps we have not gone to lunch. Stick with us here. We're sort of at the mercy of our camera that's in the courtroom. I would say that I was very curious if they had in fact gone to lunch, but the fact that our camera is back up tells me that we may be going back to testimony. So stay right here with us as we wait for the continued trial in the former Richland County. We're getting some movement from our camera, which is telling me he's putting it to the ground, which may in fact tell us we have lost that shot, and we are in fact now at lunch. Again, folks, we're at the mercy of the camera in the courtroom. We are going to take our break as well. We're just going to put up our slate. For those of you that are watching on various platforms, if you are watching on one of our platforms where it is cut out entirely, and we're going to get a note here, 10-minute break, we're going to finish with lunch. So we are not, in fact, now going to lunch. We are in our 10-minute break, which is on top of the previous 10 to 15-minute break as we are waiting for the testimony to resume, and then we will go to lunch. For those who may not have seen this, and let me finish this first of all, we have our 11 o'clock news coming up, so we're going to have to switch some of our devices here. So if suddenly you're watching our stream and it cuts out, that means you can go to cleveland19.com, click on the Richland County Corrections Officers Trial, and we will be live streaming in there. If you're on one of our platforms, maybe Facebook, one of the other digital platforms, and this stream continues, then you won't have an issue. But if suddenly here in the next few seconds this cuts out, go to cleveland19.com and you can resume watching there. But what we're going to do in the meantime is let's show the video, even though it is tough to watch. People still have questions about it. And if you're watching this and putting yourself in the shoes of the jury, this is really the most important piece of testimony here, the most important piece of evidence. You get to see Rios in his cell. From what we have heard from testimony earlier, he is acting erratically. He is potentially in a situation where he could harm himself. You will have to answer for yourself if you think that's true, the way he's acting in his cell. And then he was actually the supervisor at the time. He's the one holding the camera, and then you'll see as they get Rios to the ground, he hands off the camera so that he can get involved in trying to restrain Rios. But he it said on the stand that split second when they open the door and Rios bolts out of there, he said in his 20-plus year career, he has never seen anything like that, never seen an individual move that fast and get out of a cell into that booking area. So make sure you pay attention to that. Here's another thing I want you to pay attention to. When we get to the end of this video, you'll see the bald-headed corrections officer. That is Mark Cooper. He's the one on trial here. And are seeing our shot come back up. So perhaps we're getting close to testimony. If we do, we'll bring you right back to that. But as you watch towards the end of this video and you see Cooper with his foot on the back of Rios, and then he puts all of his weight on Rios, I want you to ask yourself this. If you're on the jury, why are the 4 other corrections officers who are in various positions on Rios. One a little bit further down the back. There's a couple on his legs. Why are they not being charged with anything? And if you are the jury, how does that weigh in your mind? Why is it just Mark Cooper? Is it because he puts his full weight on there? And why not the other corrections officers? Let's show you the video. If we get back to testimony, we'll cut it short. Take a look.
What's his last name again?
Rios.
Rios, I need you to come down so we can. Okay. All right. All right. I'm not going to call anybody unless you come down from down here. Okay, this is the last time I'm going to ask you. I've asked you for like 5 minutes. I'm not going to do it anymore. Okay? We're going to put you in a restraint chair for your safety due to not listening and being on a divider, causing a risk to harm yourself. We don't have time to continue that all night. Okay? All right, this is the last time I'm asking, and we're going to go in. We're going to go ahead and put you in a chair.
Why can't you just open the door?
Right here, go. All right. Come on down. No.
Handcuff.
Is that a yes or no?
I'm supposed to.
Go ahead and turn around. Put your hands behind your back and cuff up for me. If not, we're going to come get you. All right.
You guys
No.
are wrong, man.
Okay, we're coming to get you.
Ready?
Let's go. Go. Cuff your back. Hands behind his back. Here.
Again, I'm sorry, but I'm not sorry because I will not. I'm not going to let any kids or any family see this happen to him or hear it. Simple matter of respect. Everybody knows what happened. Man, they love playing this tape, boy, I'll tell you. You know, don't get me wrong. It needs to be out there for sure. It needs to be out there. Just, now it's becoming commercialized for them. So horrible. It's giving me anxiety, man. It's almost over. I apologize again. There's, hey.
But it is the reason that we have that video, that we have this trial of former corrections officer Mark Cooper facing manslaughter and reckless homicide. He was the officer that you could see standing on the back of Rios when they got him down. I'm going to play the video from Friday, new video that we got during testimony. This shows the split second that Rios runs out of that cell, and it is quick.
Yeah, he's faced. He got the drop on him. They were made.
Ready?
Yeah. Go.
Right there. How many men did it take to take him down?
Where was he really going to go, though, for real?
There's, according to that video, I can see one.
Now we're gonna come get you. All right.
You got
No.
it wrong, man.
Okay, we're coming to get you.
Ready?
Yeah. Go.
Right there. How many men did it take to take him down?
There's, according to that video, I can see one.
And that was the prosecution saying if this was somebody that needed to be stood on the back of, how was it that one individual was able to take him down when he rounds that corner? Again, this has been a back and forth trial. Every time the defense, and that's what you expect in a trial. But again, put yourself in the shoes of the jury. This is going to be awfully tough. You're sitting there, you're being told two different things on two different sides, that he was so high on meth that he was able to get out of there in a split second, and that the reason he was had that meth in his system was because he must have ingested a baggie. He had plastic in his gut when the autopsy was done. And that must have been what killed him. But then on the other side, you have on the prosecution, the state side, they say, no, absolutely not. It was he suffocated because he had a man standing on his back right near his neck and his chest, or on the back, on the reverse side of his chest, and that this was asphyxiation, and that he died because of 7 days later. Because of that, basically on life support once he got to the hospital, and never regained consciousness. So a lot at stake for a corrections officer here facing manslaughter and reckless homicide. Give you a look inside the courtroom. We're still looking at the ceiling, which tells us we are still on our break, but we should be coming back soon. We had a debate between the prosecution and the defense in the questioning of the lead investigator on this from BCI. That second video that we showed you, this video here, he had never seen this video and this version. And that's what's curious, is that according to testimony that we've been hearing, the expert that came in for the prosecution that said that this was a man who died being suffocated. Well, that man was never shown this video, and the BCI investigator, the lead investigator, had never seen that angle of this video. So the defense trying to chip away here. Why didn't you watch that angle of the video? Why didn't you have the plastic bag tested for drugs that was found in his digestive system? Why didn't you review all the video? Why didn't you ask the hospital if they had kept any urine samples from Rios or any other samples while he was in the hospital for those 7 days? You heard the BCI detective say, well, the reason we didn't, I didn't, it was his phrase, it was his investigation. The reason he did not order that baggie to be tested for drugs is that he knew it had been in Rios's digestive system for at least 10 days, and that the amount of acid in his stomach would have eaten away any trace, according to him. It will be interesting when the defense finally takes over on their portion of this case. Remember how I said you can go out there and find an expert that will basically get paid, come in and testify for you, and can basically get them to testify the opposite. It makes me wonder, if you are the defense, is there an expert out there who would have said that testing that piece of plastic absolutely could have found some sort of trace evidence, traces of methamphetamine, if that's what was in the bag, and that it absolutely should have been tested by BCI. Simply having the detective say, well, at one point I had some training, some medical training in college, and I have a basic understanding of biology, and that the acid would have eaten away any evidence of that baggie. That's the reason he is saying he did not get that tested. But you hear it, we're not going to play the surveillance, the camera of Rios on the ground again, but you even hear the corrections officer that's holding the camera. She says something to the fact that he's on something because of his erratic behavior. And I want to play that again. I kind of noticed something watching this second, a third time. Watch Rios bounce off that wall. He hits that wall really, really hard when he comes around the corner. Watch again as he's going to bust out of the holding cell. He's going to make the first turn. It's the second turn that he makes and hits the wall pretty hard. And I just want to watch this again to see if this could have had any impact. Not this wall, right there. No, he just sort of glances. It's sort of a glancing blow on that wall. And then he is taken down by the corrections officer. Still waiting for the trial to resume here, for testimony to resume. We believe that we will finish up with the BCI investigator, and then the judge will be releasing the jury for lunch. Again, this has been a really discombobulated trial from multiple angles.
You could say that
Granted,
again.
this is Richland County. They don't get a lot of cases like this, regardless of whether it's a corrections officer or not. This is a smaller county, probably not a lot of homicides in my guesstimation here. We've been covering this area for quite a while. We get a little camera movement here, which tells me we might be finally closer, and focused on the door here, which tells me we're waiting for the all rise and for the judge to be brought into the courtroom. So we'll stick with this as we are pretty close to getting the trial underway, testimony underway. Again, we will finish the testimony of the lead BCI investigator and then go to lunch, according to what we've been told. We'll wait and see, but I thought that announcement 20 minutes ago was a little bit of an offshoot when we were told at 10:50 that the jury was taking lunch. That's only been hearing testimony for an hour and 50 minutes, and for a trial that's now entering its second week. This trial started last week. The fact that we are still hearing from the prosecution's team, being that this is the lead investigator, I would tend to believe that this may be the prosecution's final witness. So perhaps the defense will start its case when we come back from lunch. Of course, just speculating on that, but we will at least be a little closer. And it looks like we're getting closer at least.
And hopefully at that point they will have some.
So we will wait for the judge. We just saw his court reporter now going back into where the judge is. So we're a few minutes away, just waiting for the judge to come back in and get the all rise. It's been a very complicated case, to say the least. A lot at stake here. Let's also remind you that Corrections Officer Mark Cooper, he stayed on as this investigation was continuing. It took more than a year before he was charged. And once he was charged, that's when he was fired. But he had stayed on as a corrections officer. That again goes back to this idea and a notion that you can put in the jury's head, is that they didn't even know this was meeting the level of needing a grand jury, of having potential charges a year into this. And the fact that the corrections officer was continued his career at the Richland County Sheriff's Department and the jail shows that at least in their opinion, that this was a routine situation, a detainee that then died 7 days later. Now, you know, had the inmate Alex Rios died that night or maybe the next morning, you can see where there may have been a little bit more urgency, that the magnifying glass would have been used a little quicker. But the fact that he died 7 days later more than likely had a role in the delay in the investigative process. So again, just waiting for the trial to begin here to resume. So we're just going to leave this shot up here as we wait for the judge.
Alright. You got it wrong, man. Okay, we're coming to get you. Ready? Let's go.
Right there. How many men did it take to take him down?
Dan DeRose with Channel 19 here as we wait for the Richland County Corrections Officer for the testimony to continue. Let's keep in mind once the defense is given this case, they will be able to call all of their experts, their witnesses who are going to explain how this should be handled. Let's point that out too. It came out in the testimony of the supervisor there at the jail when they start talking about policy, and they read through the entire policy of what level of force can be used depending on the situation, depending on the inmate. And of course, this was at the top level. This is an inmate who has escaped from their cell, an inmate who was on suicide watch. And here we go, we get our all rise. But it was brought up a couple of times about policy and training, and are they ever trained to stand on the back? And the supervisor said no, but then the defense said, hey, in that whole booklet, nowhere does it say what you are or aren't supposed to do.
Agent Lehnhart, you indicated with respect to the specimen, urine, or any blood that may be available at the hospital, you testified on redirect that you knew that it would not have been there at the hospital. Do you recall that?
Yes.
Okay. And just so we understand how it is that you reached that conclusion, what you knew was what the retention policy of the hospital was, correct?
That's correct.
And what you knew is that you got the case 10 days in, right?
Correct.
And that was past the hospital policy for retention of urine and blood specimens in a case like Mr. Rios's.
Correct.
Or any case, any hospital stay, right?
Yes.
So you were familiar with the policy for retention and that the time had passed, yes?
Yes.
And from that, you concluded that the specimen wouldn't still be at the hospital.
Right.
To be clear, you didn't confirm that by ever talking to any hospital staff, administration, doctors, nurses, or anyone who could actually check, correct?
True.
Okay. Now, last piece of this, you indicated in some questioning about failure to have plastic bag-like object analyzed.
Yes.
You indicated that based on your experience as a law enforcement officer, the time that that bag would have spent in Mr. Rios' stomach, your belief is that would make it unlikely that anything left inside the bag would be available for testing due to stomach acids.
True.
You based that on your experience as a law enforcement officer,
Yes.
not as a medical doctor, right?
Right.
And not as a forensic pathologist, right?
Correct.
We've heard the testimony of, I think, 4 medical doctors over the course of a week in this trial.
Yes.
You did not hear any of them make that same statement during their testimony, correct?
Correct.
Okay. And so, in the end, you had possession of this piece of evidence on the chain of custody, came into your possession on September 30th, and you had a degree of control over that piece of evidence from that day until the day you brought it into court here for this trial, correct?
Yes.
You've heard all this testifying about drugs or not drugs and that sort of thing, right?
Yes.
Looking back, wouldn't it have been prudent just to get a confirmatory test done so we would be having all this conversation?
Objection, argumentative.
Well, and maybe draws a conclusion, so I'll sustain.
Bottom line is, you simply did not do that in 4+ years on the case, correct?
That piece was not tested.
Nothing else.
Okay, do any of the jurors have a question for Special Agent Eric Lehnhart? Okay.
So this has been an interesting part of this trial as well, something I've never really seen before. I'm not saying it's doesn't happen, but I just haven't seen it very often. Whenever in this judge's courtroom a witness gets done testifying, the judge then turns to the jury and to see if they have any questions of that witness. And you just saw the bailiff for the judge walk over to the jury. The question has to be written out. Then that question goes to the judge, and he has a sidebar with the 2 attorneys because they have to look at the question itself and debate whether that is a legitimate or a legal question that can be asked. You can't just, you might say, well, boy, shouldn't you just ask, if you're on this jury, shouldn't you ask the question if this lead investigator thinks he did it? Well, you can't ask that question. That's hearsay, that's speculative. His answer would be speculative at best. And so you can't just ask anything. But it has been interesting in the past couple of witnesses to see the questions that do or don't get answered by what's the consensus of whether or not the question can even be answered. You heard the defense there at the end again, and I've been pointing this out all morning. You are the lead investigator on this from BCI. You had that plastic bag for 4 years, the bag that was taken out of the digestive system. Let's see what we get for an answer. And you never had it tested. And that was the point he was trying to make for the jury.
Arrested and brought to the Richland County Jail. You indicated that you didn't see any video of him going through a scanner, but you did see in the booking process that there were some check boxes. So the question I think relates to that is, was there any notation when you saw those check boxes of his behavior when he was being booked into the jail, not when he was in the booking room, what we've seen, but prior to being put into the pod, the general population pod? Was there anything that you noted that you recall about his behavior or attitude at that point, impairment, anything?
The paperwork indicated that was done by the COs that booked him in. There was no indication on those documents of they're recognizing him as being impaired or being agitated or anything like that. So it was, the paperwork was pretty unremarkable, and when I say that, I guess I mean that it wouldn't have been any different than any other person coming into the jail. There wasn't anything specifically on that paperwork that was marked to recognize the fact that he had been an issue at that time.
Does that bring up any additional questions from the prosecution?
No, Your Honor.
From the defense?
No, Judge, thank you.
All right, thank you, Special Agent Lehnhart, you can step down, appreciate it. Does the prosecution have any additional witnesses that they want to call?
No, Your Honor.
All right, so ladies and gentlemen, what's going to happen is, the state's going to rest at this time, which means the prosecution at this point has called witnesses they want to call, what we call in their case in chief. So what I have to do now is I have to do part of my job as judge of the law that you don't need to be involved as part of judge of the facts, which is we're going to go over exhibits and talk about exhibits outside of your presence. So I think it makes sense, we're a little bit early, but I think it makes sense to let you have a lunch break. And so then have you come back. Now, when you come back, it's the defense turn to decide if they want to call witnesses. They don't have a burden of proof, they don't have to call witnesses if they don't want to. They may want to call witnesses. There's also some conversations that I need to have with the parties about jury instructions and things like that. So why don't we have you come back in an hour and 10 minutes from your lunch break, and at that point, we'll see where we're at as far as if any witnesses are going to be called by the defense at that point or not, and go from there. But we are making progress, so we are getting towards the latter end of the case, I suspect. So we'll see everybody after your lunch break. Same instructions. I always tell you, if you've heard them now probably 10 times, same instructions about not talking to anybody, not having any opinions, no media coverage, paying attention, and no research or investigation. See you back here in about an hour and 10 minutes. We'll continue on. Thank you.
Dan DeRosa with 19 News. Now we're going to stick here for a couple of minutes. I know the jury is being sent to lunch, but you heard the judge say that he has to take care of some issues with both parties before the defense can start calling witnesses. Now, one of the things that is generally done at the end of the prosecution, when they're done and they say, we rest, we have no more witnesses that we're going to call, normally the defense will make a motion. And that motion will be to the judge, something to the effect of, Judge, we don't feel that the prosecution has made their case beyond a reasonable doubt. We don't think that they have proven anything to the jury. And this happens really across the board in all trials. At that point, the judge has to decide, well, is the defense right? Did the state not prove anything? And the judge could throw out the entire trial right there and say this is over. And it does look like we're going to go back on the record that it's really a last-ditch effort. And it does not work 99.999% of the time. But as a defense attorney, you have to try it. You have to throw it in there. So let's listen in on the court.
Yes, Your Honor.
Yes, Your Honor.
Subject to the admission of the exhibits, we would rest, but yes, State's Exhibit number 1, the titled Kent Harshbarger, Coroner, Montgomery County, Postmortem Examination.
Any objection to the autopsy report?
No objection.
It's in. I have State's Exhibit number 2 being the death certificate. Is the state offered that?
Yes, Your Honor.
Is there any objection to that?
There's a couple of them. This is the death certificate that indicates the manner of death. Accident.
Cause him in.
Cause of manner of accident, yeah.
It's the supplement. Yeah, no objection.
Okay. 3 is the, looks like video of the incident in the jail. That's the handheld. Any objection?
Well, it's both, Judge. It's the handheld and the compilation, and they're both contained within State's Exhibit number 3, and we've played that. It's been identified by several witnesses, and the compilation was identified by Agent Lehnhart.
Any objection?
No, sir.
That's in. State's Exhibit number 4 and number 5 are photographs of Alex Rios. One is a photograph of him, and one of them is photographs with his kid that were offered, I think, when his mother testified.
Yes.
Being offered?
Yes.
Any objection?
No.
Okay. 6 is the item taken from his stomach during the autopsy being offered.
Yes.
Any objection?
Nope.
All right, that's in. 7 would be Dr. Mitchell's report, expert report being offered.
Yes.
No objection, with the exception of we think it's appropriate to redact the portion of the 2 lines with respect to the Davison report and the phone summary of the interview with scientist Davidson. Their bullet points, maybe 3 and 4, that are the subject of the discussion we've had in this case. I don't think there's an issue with that.
And I think we agreed that those would be taken out. So, yeah, I'll allow that in with the idea that where it says Bureau of Criminal Investigations, BCI report, polyvinyl chloride material, we black that out. And then the next blackout will be notes taken by Special Agent Eric Lehnhart during the Friday, June 12th, 2020 cellular phone discussions on scientist Davison's findings. I think that we agreed that that would also be blacked out, but otherwise I think everything is okay on that report.
So Judge, I don't have a black marker. Does anyone? I still do that right now, so there's not a mistake.
And if there's bleed through, we could even make a copy of it.
Yeah, I think we just want to have like a log put over it. I mean, they can still like look at it and then make a copy of that, put their sticker on it, and that'll be our cover page, but we'll get there.
Okay.
You know, as long as it's complete. I just don't want the jury trying to look at the portion reports and things like that.
Yeah. Is there any motion,
Are those all the exhibits?
I think those are all the things.
That's the rest.
All right, any motions being made by the defense?
Yeah, at this point, we will make a motion for acquittal pursuant to criminal rule 29. Of course, we're aware of the standard at this point for a fish case. I mean, it's like a sort of mistake. Even still, we are asking the court to dismiss this case, given the evidence that we've heard, specific attention to the competing expert views in this case as to cause of death. The quality of that testimony as it relates to reasonableness of force and also proximate cause. We think that there are legitimate issues there as well for this stage of the proceeding, let alone as relates to later being a jury question. Specifically, the state has offered testimony from their expert indicating that the suspect proximate cause of the death, the theory being the felonious assault and/or assault committed by the 7 seconds that our client is on the back or neck area, depending on the testimony that we've heard viewing the video. With respect to this case, we've heard extensive testimony regarding reasonableness of force. While we're still arguing over the appropriateness of how that will be discussed in jury instructions, we believe it is right smack dab in the middle of this case, and it's relevant for the discussion that we have right now. Specifically, there was discussion on the first break this morning about use of force and reasonableness in the context of the Ohio Administrative Code. Mr. Thompson did correctly point out that the code section that we were initially bringing to the court's attention speaks as to corrections officers in the prison setting. We continue to look at the Ohio Administrative Code during the 10 minutes that you gave us before getting back on with Officer Lehnhart or Agent Lehnhart. And specifically, we can direct the court to the jail section and the sheriff section of the Ohio Administrative Code that specifically grants the ability to use reasonable force in the reasonable to to ORC 341.01, indicating sheriff shall govern and regulate according to minimum standards for jails promulgated by the ODRC. The argument has been made that policies cannot supersede or otherwise trump the ORC. Well, this is directly contained within the ORC, and this is law, and it specifically lays out in OAC 5120:1 through 8 full-service jails, and talks about use of force and the essential standards, and we would direct the court's attention to that. Compare and contrast those with the testimony that was offered, and specifically the use of force continuum, which was identified as the policy in place for use of force at the time. And what the court will find is it's a virtual cut and paste job from the Ohio Administrative Code section governing how the sheriff shall implement use of force policies as reasonably laid out in the Ohio Revised Code as the law. And those provisions, as I indicated, are what are laid out in the policy that is at issue in this case. And we feel it's clear this was an effort to bring a, not arguably, but obviously non-compliant inmate into compliance for his own safety and that of everyone else in the jail, including the guards, and that the restraint is not over until the inmate, per policy, is in fact caught. And in this case, that did not happen to the very end, and certainly did not happen prior to our client using the force that has been deemed as the force alleged to have caused the death. We believe every measure taken by our client in this case was reasonable, and looking only at the tragic result ignores what was happening before and during the time force was used. When I talk about that, I speak specifically as to the actions of Mr. Rios. We do not believe that any reasonable jury would think otherwise, and we ask the court to conclude as such in Rule 29.
That code section, before I hear from prosecution's response, ORC 341.09.
01, I believe, Judge.
34101. Is that the one?
Yes, and that speaks about the sheriff governing and regulating according to the standards for jails promulgated by the ODRC. So it essentially transitions that. Essentially accounts for exactly what Mr. Thompson was arguing on us about 15 minutes ago, and directs us to the jail section. And when we do that under OAC 5120:1 through 8, what we're going to see is a cut and paste job essentially by the Richland County Jail to be in compliance with Ohio law when it comes to use of force policy. And so once again, getting a little far afield here, assuming that this trial has continued on, notwithstanding the court's current ruling, we believe it's appropriate to revisit just the standalone jury instruction as proposed or altered to clearly take into consideration the Ohio Revised language. Thank you.
From the state.
Yes, Judge, thank you. And looking at the evidence in the light most favorable to the state of Ohio, which is the standard this court is well aware, the state believes that a reasonable jury could find that Mr. Cooper is guilty of all three of the charges. We've presented evidence of each and every element of each and every offense. We presented evidence of cause of death and manner of death. We certainly believe the standard is knowingly cause or attempt to cause, knowingly cause serious physical harm. Clearly the death is serious physical harm. I think it's clear that Mr. Cooper acted knowingly. Mr. Cooper acted knowingly in causing physical harm, necessarily as a lesser included offense. And certainly a jury could believe, if they don't believe he acted knowingly, that his actions were reckless with heedless indifference to known consequences or risks, being that when you stand, when you weigh 250 pounds and you stand on a prone person's back with their arms and legs behind them, that you could cause serious physical harm and or death, thereby resulting in death. So, Judge, we believe that, again, a reasonable jury could find, don't have to find, but that's not the standard, could find if believed, if all the evidence is believed that the state has offered, they can find him guilty of all the offenses charged, and we ask that the motion be denied at this time.
Thank you, Assistant Prosecutor Salisbury. I do think that in the light most favorable to the state, which is how the court must look at it, I think there is a reasonable jury could conclude in the light most favorable that the defendant did violate the sections that he's been charged with, so all of the rules of Rule 29. As to the issues, I did have a chance on the break I looked at a State v. White, 142 Ohio State 3rd, 277, State v. Bolton, 2018 Ohio 1551, another State v. White, 2013 Ohio 51, and just really glancing at those briefly, I think they do talk about a situation where a law enforcement officer on duty used force and ultimately got charged, and so there's discussions as to justification and those kind of things. So I do want to look at those. I also would want to look at the new code section that's been provided, the administrative code section that's been provided, and look at a possible instruction either as to reasonable force related to corrections officers or to this affirmative defense of justification as related to a corrections officer. Truthfulness, at least, I will say, at least these cases, at least the first one I looked at, looked like it was directly talking about a situation that's similar to what we have here, which is an officer on duty trying to arrest somebody or at least detain somebody, and then ultimately that individual was shot. It's different because it was gun use, but the discussion is similar, such that at least it gives me somewhere to start in looking at this.
If I may, Your Honor.
Yeah.
If you're referring to the State v. White, the original case that was cited,
Yeah. Well,
that was to a law enforcement officer. Corrections officers are not law enforcement officers. I'd ask the court to make that a distinction, in its analysis.
And I'll look, the other two, when I jeopardized the first State v. White, the other one two popped up. So
I believe, I haven't looked at the Bolton case, but I believe all of those cases refer to law enforcement officers.
Okay. I understand. So I guess what we'll do is we'll take our lunch break and we'll come back and go from there.
That's fine, Judge. We don't require a record for the next portion of the hearing, but I would like to talk about scheduling.
Okay, all right. So we can go off the record. Schedule?
We request to cut the string as well.
Okay, since we're off the record, we can just go ahead and go off.
As you heard there, the defense attorney is asking for an off-the-record discussion with the judge, to which the judge then just looked at our camera and said that this needs to cut off the stream. That is understandable. If it's not on the record, and if it's not being taken into the record by the court reporter, then we turn our cameras off. That goes without saying. So let me explain what you just saw there. You saw the defense ask the judge to dismiss this case, that they didn't meet the burden of proof, that a reasonable jury would never find his client guilty based on an Ohio Revised Code of getting an inmate who has escaped, getting them in custody by any force necessary until the cuffs are on. They argued that the use of force was all before the cuffs were put on Alex Rios on the floor. You then heard the state say, no, that doesn't apply here. And even the cases the judge was citing, that those were police officers that were using deadly force in a situation. You have to remember, corrections officers are not sworn officers. They didn't go to police academy, and so they are not subject to the same sort of rules that apply for police officers. The judge is going to take it under consideration. Look, we see this in every case. When we get to this midway point, when the state wraps up their case, you get the defense that starts before they start their case. They start with a request for the judge to dismiss the entire thing. Again, 99.999% of the time, the judge never dismisses the case. They let it play out, and they let the jury make the ultimate decision. They're going to take their lunch now. I believe they will probably come back on the record around 12:30, maybe a little bit later, to discuss a couple of things before the jury comes back in the room, to be able to discuss what the defense plan is, who their experts are, and where they're going to take their testimony in the next couple of days. So it took exactly a week for the prosecution, for the state to lay out its case. We are not sure how long it will take the defense. It all comes down to how many witnesses they want to call. So we too are going to put up our standby slate and wait for the court to go back on the record. Again, that's expected to be around 12:30, so we will pick up our stream about then. Until then, I'm Dan DeRose with 19 News. We'll see you around 12:30.
Dan DeRose. I don't know what he. Yeah, man. This is it's been a hard case to follow for me because one, it's one of the first ones I've actually followed and commentated on at the same time. And then at the same time, we have you know, we have the sorry, give me a second here. We got the prosecution, we got the it's just it's been tough for me to watch. It's been tough for me to commentate. And it's also, I'm not saying that, that I'm giving up or anything like that. It's just that the intensity of the case itself has been really, really high. And with me, like, trying to run the stream, right? I'm running into, amateur issues, basically, is what I'm getting at here. That will get better with time. It's been hard to run the stream, make sure that I'm not letting anything out that shouldn't be seen by the family, minors, so on and so forth. So me following this stream, I know once I watch this back, I'm gonna be like, what was I saying? A lot of times. The rest of the, usually I'm on point. Let me put it that way. This maybe not so much. But I'm trying. I'm definitely trying. And I'm not willing to just give up here. I'm going to keep going. Definitely going to keep going with this trial 100% and move on to other things. This has been a really weird trial. They keep doing this on the record, off the record thing. I mean, like, they have, I don't know. I guess the jury doesn't have to be present, which I guess I'm sadly mistaken that, the jury should be there when they're speaking on the record. Because it's on the record, right? It's not a sidebar. It's not, can you guys go into the back? Like I don't know. I've observed a lot of trials, and this one is really a confusing. It has been really confusing at times. His defense to me is shit, and I feel like they were. I feel like they've been going for, we'll see what happens. I'm not gonna say what they're trying to do and what they're not trying to do at this point, because I'm an idiot and there's things that I don't know, and I'm not gonna sit here and try and pretend like I do. I'm just observing and reporting on what I am observing. But with that said, it's been crazy. It's been absolutely crazy. They keep switching back and forth. You know, it's like, and the guy, and no cuts to old DeRosa, Danny the Captain Cap DeRosa, Captain Cap DeRosa. It's no cuss to him, man, but at the same time, he's really just certain things. He seems like he's reaching on. Other things, it's like, I don't know. Maybe he's just as confused as I am, and that's why this whole thing's so crazy. I don't get it. I don't know. I'm sure you don't want to hear me mumble for the next, I don't know, hour, however long this lunch break's gonna last. Yeah, it's just very, very strange. It's very odd. I don't know what to make of it. So they've been defending the case, so I don't know what the defense is gonna pull. If that's what the prosecutors pulled, oh man, I can't. I'm not sure if they're. I don't know. Do they have witness? Like, where do they have witnesses? I mean, at one point in the trial, they were talking about swearing in one of the lead attorneys on the prosecution for clarity on testimony and what is and what isn't. This has been crazy. It's been crazy. The video speaks for itself. I don't recommend watching it. It is definitely it's clear. It's clear cut. And the man that they had in there from the FBI and the whatever multiple agencies that he's worked for as a pathologist, he clear cut says that he died of asphyxiation. They keep trying to blame this on drugs. Drugs were a factor for sure. Like, let's just stop with that, though. Let's stop with that. Because if you would have took the precautions to put him in a dry cell, and this is what scares me about this jury, is that if they're not privy to how things, like, they didn't have anybody come in and say, well, let's go over, we have an expert on and this could have been for both sides. Like he said, you can get anybody, you pay somebody, they're going to say what you want them to say. Well, I don't know. I guess that's how it is. I'm not I'm not that type of dude. I won't take money to just say something. I will if I was an expert and I was telling you something about something, I'm not going to tell you what you want to hear, but that's the game of law, right? Sad, it's sick, and it's twisted. There's no morals, and I completely went off topic. My point is if they would have had someone in there who actually talked about what a dry cell is, and since they already had him in the turtle suit, so they knew that he was a threat, right? He's a threat. So now knowing that, take him and put him in a dry cell. Don't put him in a cell where he's up on a thing. Come on, man. That's just a setup. And then he busted out the cell. He busted out the cell because you let him out the cell. And I understand you had to do it for the reasons that you did it for, but the same reasons that you did it for is the same reasons why he shouldn't have been in the cell. He should have been in a different cell. Tell me I'm nuts. I don't know. If you've even made it this long into the show, cast, reporting, whatever this is, the live. I just don't see how it could possibly go any other way than him legitimately getting every bit of what he deserves. I'm sorry, man, but I'm not sorry. They all played a role in it, and they all had a lapse in judgment. And if nothing else, they should all be reprimanded for that. What that should be, I don't know. I have no idea. I'm not here for that. I'm not here to hand down tell people, whether they should or not. Go to a higher place. Do I think he needs to seek God? Hell yeah. He needs God in his life, for real. And on the same token, they need to seriously go over their policies. I had to laugh. The dude saying that they don't usually have these situations. Are you crazy? Do you know how many cases Ohio has like this? They're full of shit. They're full of shit. And it shows. It's just a cover up so they can look better and keep all their dirt covered. They just want to keep the dirt covered. Point blank, period. I'm gonna put this lunch break sign up for the everyone. And you know what? I even put a little I don't know. I just don't really want to this is just so I guess so we everybody knows it's break time. Go get some lunch. Get yourself something to eat. I'm personally gonna go walk my dog, and I don't know, maybe make a sandwich. I'm gonna make a sandwich. But thank you for being here. Be right back shortly, as soon as lunch break is over. In the meantime, I got this whatever it is playing. Just so you know that we're in a break. waiting on them to come back. I'll be back before that. I need a minute. Thank you for everybody who has tuned in or tunes in later. God bless, all the best. Thank you very much. You're very much appreciated. Very much appreciated. All these, for real. I mean that. Trying to figure out what I'm doing here. Obviously. And it is lunch break. We'll be right back. See you soon. Just like, you know, I'm still here, still waiting. See what goes on. I'm gonna finish eating this here lunch.
He was seen in the video standing on the back of Alex Rios. Rios would go unconscious there in the jail, transported to a hospital where he would die 7 days later. The judge is back on the bench. This could be procedural. We'll see if the jury is back in the room. The defense is about ready to start their case, which means the judge needs to make a ruling. First of all, the defense asked for the judge to throw out the whole case. That's something that's done at the halfway point of just about every trial. The judge is giving his reason now why, whether he is or is not throwing out the case. Let's listen in.
Necessarily in the, I don't know that the court gave the instructions because it was an affirmative defense or gave the instruction and then the defendant argued for an affirmative defense. But I do think that, I think that if I don't say anything about reasonable force related to this situation, I think that the problem is the case law that I've been looking at says I have to. Now, do I do it as an affirmative defense? Do I do it just as a blur like this, the defense wants me to give? I don't know. But that's where I'm at. I'm not prepared to tell you what that instruction is going to be right now, because literally I have about 30 minutes to look at all this. But that's where I'm at. So I think the most prudent thing would be to send it for home and do this at come in, maybe we meet early in the morning, we talk about it, and I tell you my decision, and then you can argue about it. Likely at that time, my decision will be my decision. And we can argue about it, but probably will be whatever it is at that time.
Judge, if we'd like to make a filing, even perhaps before the end of the day, to serve on the other side, and
yeah, both sides
or first thing tomorrow morning.
Yeah, both sides want to help me out. And I don't know what the state's thought process is. It just looks like if you don't put anything in there at all, it looks like the one case says you must. Now, it's talking about law enforcement, but it's talking about use of force in a situation where someone has the authority to use it. And that's what we're talking about in this case. COs and police officers have an authority to use a certain amount of force. What they don't have is the authority to go beyond that reasonable force. And then the issue in this case becomes, we know Alex Rios died, but it's not like a situation in these cases where the officer pulled his gun and shot the person. That's clearly deadly force. In this case, argument of standing on someone's back for that period of time, is that deadly force? Some say yes, some say no. So that's another issue that's convoluted. So thoughts from state or defense on that? My thought is I send them home and try to fashion something and go from there.
Well, Judge, if you intend to have your mind made up when we get here tomorrow morning, we'll do the best we can in the 3.5 hours that we have before the clerk's office closes to get something filed. And we, of course, will serve it on Mr. Thompson, Mr. Salisbury. We also would reserve the right, I guess, to email something this evening if we can't get there. And I would text Mr. Thompson to let him know that we did, vice versa. I assume would be reasonable. And we also would email it, I guess, maybe, or fax it to the court. I don't know the best way to get it to the court.
It might be helpful to come back.
The court's closed at 4.
Yeah, it might be helpful to come back at 3:45, both sides and tell me what you have, because, again, what I'm afraid of, and what I know probably gonna happen is we get back here at 8:30.
Right.
I have something in mind. Probably both sides won't like it, will be probably where we're at, and that's typical. And then we're gonna be trying to rehash and change it up and do stuff. So I'd rather have something in mind from both sides, even if you hate it,
Which is
I'd rather have it, you understand.
We'd at least like to be on the record as to where we think it is, and I think we can be in that position by 3:45 this afternoon, or at least something we could file.
You know,
We
it
understand
becomes
that.
for us, it's logistics.
Right.
And we're an hour away.
Yeah,
So we lose an hour before we get started.
it's true.
So
What about,
if we're able to email it,
yeah,
and email it directly.
Could we do it by a call? Could
Can't
we
believe
do
it.
it?
Hearing it.
they'll be driving for an hour before.
Yeah.
The idea, I think their issue, not to speak for them, but I think that 3:45 is what's problematic. It sounds like they're saying, we could get you something today that you could have to be working with this evening, I think it's reasonable we can get something, both sides can get something this evening. It's just a matter of how do we get it to you, given the fact that the court will be closed. Is that fair, of course?
Yes.
Yeah, and I'm good with that. However we want to do that, whether we email it to us, fax it to us, whatever. You know, and you know the stuff I'm looking at. I put on the record the cases I'm looking at.
I'm not good with this
That's where
right
I'm gonna
now.
start and try to figure it out.
Does that, Judge, if I could ask,
This is
does
not
that
me.
include a definition of what is reasonable force? Or it just says reasonable force?
Well, when you look at the case law and it talks about, I'm looking at the Ohio Supreme Court, and even just to put this on the record so everybody understands where we're at. This case by the Ohio Supreme Court from 2015 was far from unanimous. It basically had concurring opinions, dissenting opinions. You know, people concurred in part and dissented in part, so it was all over the map. So we're at a point where this is very difficult for any of us to wrap our heads around what this is, because even the Ohio Supreme Court in 2015, those justices were all over the place trying to figure out where exactly this should come down. And so it's that kind of an issue, but it said that one of them says Ohio courts recognize that a police officer is justified at common law to use reasonable force in the course and scope of his law enforcement duties. And then it cites the second district case that talked about that case involving the prosecution of police officers for assault and battery. The peace officer duly employed is not liable for injuries inflicted by him in the use of reasonable necessary force to preserve peace, to maintain order, to overcome the resistance to his authority. Thus, an officer making an arrest is justified in using sufficient force to subdue a prisoner, although not acting in self-defense. However, if unnecessary violence is used by the officer in accompanying his purpose, or if he assaults the person with whom he is arresting without just cause or excuse, especially after resistance to his authority ceases, then he loses these protections under the law. So it goes all the way back to a common law idea that you have these rights to do your job, but you can't go beyond those. So I mean, I think that the idea would be explaining to the jury that, and trying to do this in a way that fits this case, but that as a corrections officer, he does have the reasonable use of force, but he can't go beyond that. He can't go beyond it. So it's going to be me trying to fashion something like that from the case law, and I'll look at the Ohio Administrative Code and try to come up with something. And of course, it says, the other thing I read in these cases, if you don't say enough, that's a problem. But if you say too much, it's a problem too. So it has to be just right. Well, that's this is it.
You're just a man for the job, Judge.
Yeah, no, all right.
We'll see what we can do to help you out.
All right. We'll bring the jurors in. We'll explain to them what's going on. We'll bring them back at 9 o'clock, and by that time we should be ready to proceed.
Yeah, this part.
Dan
This
DeRosa with
is
19 News.
insane.
What you've been watching is a very interesting development in this case.
How-
As I said, when the state rested its
Pipe
case,
down, Dan.
it's very common that the defense then, before they even present their first witness, they file a motion asking the judge to throw out the case. This happens in all kinds of cases, almost every time. And 99.9% of the time, the judge doesn't agree and the case continues and the defense calls their first witness. Well, we've got to hit the brakes here. The judge, after the defense cited 2 appropriate cases looking at the use of force when you are a police officer. The problem with that is corrections officers are not sworn peace officers. It is a whole nother breed. But the judge is saying he now needs to look at these cases, and in particular, a ruling by the Ohio Supreme Court in 2015 where it does talk about justifiable means to subdue a prisoner, and that what is determined as an appropriate use of force, because in common law or case law, a corrections officer / police officer is allowed to use some semblance of force. The judge is asking for the defense to prepare something in writing, to which it looks like he's going to dismiss the jury right now, send them home, so that the defense can get something written up and submitted by this afternoon, so that the judge can have it tonight to make a ruling tomorrow morning. Yet another twist and turn in this complicated case.
Gentlemen, when you were gone, we did have an opportunity to do some things. Part of my job is not part of your job, discussing exhibits and those kind of things. Like I told you, the state is rested. They've admitted all the exhibits. All the witnesses. They've had all the witnesses testify that they want to have testified. It's now the defense's turn. As we talked about, the defense doesn't have to call witnesses, but they can if they want to. I think at this point, it would be more prudent for me to let you go home and come back at 9 o'clock in the morning. We're getting close to being at that point where we're going to get the case to you for your deliberations. I suspect that will happen tomorrow. There are some issues that myself and the parties need to come up with, and these, they're not simple, let's put it that way. So, in the effort of trying to resolve things so that they're done properly on this side, so that you can render your verdict properly, it's going to take some work from the parties and myself. And it's not something that I want to make you sit around and wait. And it's not something I certainly want to rush. I want to make sure it's done right. And so I think it's better that we take our time and get it right so that you can deliberate fairly and accurately. So what we're going to do is let you go home, come back at 9 o'clock in the morning. By that time, we'll have an idea of where we need to be. At that time, we'll see if the defense has witnesses or not. If the defense does not have any witnesses, we're ready for jury instructions and closing arguments. If the defense has witnesses, then we'll hear from those witnesses. And unless the state would have rebuttal witnesses, then we'd be ready for jury instructions and closing arguments. And we have, so you know we have been working. I do have proposed jury instructions already done. The parties are looking at those to go over. We have proposed verdict forms already done. The parties are looking at that. But there are some things that may need to be added to this that's what we need to discuss. So that's why I think it's better not to try to have you wait around to see if we can get this done while you're waiting. I think it's easier to let you go home, come back. But it looks like we are on course to get this case to you tomorrow. Remember what I've always said about these cases. Whatever decision, whatever verdict you come up with in this case is the right decision, whatever that is. You're to disregard. If you think I have an opinion, I want you to disregard it. It's your job to decide facts, not mine. There's no time frame and no right or wrong answer. Whatever you decide is the right decision, and there is no time frame that if you can decide quick, long, whatever it is. Your main effort must be to arrive at a just verdict based on the evidence and the law and the facts that you determine have been established in the case. So we'll see you back here. Same instructions. Don't discuss the case. Don't form or express any opinions. We're getting close. We're getting close to that point where we want you all expressing opinions. But that's not until deliberation. Come back tomorrow at 9. Don't pay attention to media coverage. Don't do your own research or investigation. See you back at 9 o'clock, and we'll continue on. Thank you.
So that is, in fact, what's happening. They are going to wrap up for the day in this trial because there's a lot of work that needs to be done behind the scenes, especially on the part of the defense attorney. He filed this motion asking for the trial to be thrown out on this idea that as a corrections officer, he is allowed to use some level of force. Is that standing on the back of an inmate who's pinned to the ground? The problem is there is no case law that says what is and isn't justifiable force in a situation where an inmate has escaped. Of course, there is nothing that says you are allowed to kill an inmate unless that inmate is using deadly force or has gotten a hold of a weapon themselves. So this is going to be tough for the judge. And we heard a little bit of an indication, and I'm staying on this because I want to see what the judge ultimately ends up telling the attorneys as far as a time frame here. And it looks like we are back on the record.
I'd like to know.
If it ends up being 5 or 6 or something in the evening, is there a mechanism by which it could get to you, Judge?
Probably not like an email or fax. Probably not. If it's so, probably not that late. Probably not.
We'll do the best we can.
And is there an idea of meeting early in the morning? Do you want to get here earlier than normal? Is that helpful? I'll see if I have emails on my calendar before 9 o'clock.
So Judge, just speaking from the top of my head, what you read from that case seems to be appropriate to that language that you read. However, the only thing that I would say, that I would maybe suggest to the court, is the precursor of, if you find that force was necessary, then it had to be reasonable. I mean, I don't want it to be a foregone conclusion that the force was necessary, you know what I mean? Like, if you find that the officers needed to use force in this case, it had to be reasonable force. So that's the only kind of precursor I would add.
If I don't have anything until 9, 8:30.
It's fine. If it's okay.
Fine.
It's fine.
Let's reconvene at 8:30, and I'll show you what I have at that point. And I'm going to try to keep it succinct, but we'll see how much is in there. And then it's probably going to have everything we've talked about. You know, what Attorney Mayor provided is, I'm reading quite a bit of this out of these cases. The only difference is we're applying it to corrections officers as opposed to law enforcement officers, because these cases are an officer making an arrest where there's resistance, and how much force can the officer use to affect the arrest. This is somewhere in that vein, but not quite the same thing. So, all right, thanks everybody.
If we have things to get to your attention.
Dan DeRose with 19, just going to keep an eye on that to make sure they don't go back on the record here. But you're seeing kind of a bombshell moment play out. Normally when a defense attorney asks a judge to throw the case out before they start their defense, basically saying the prosecution, the state, they didn't meet their burden of proof. They didn't prove that a corrections officer is not allowed to use reasonable force in the case of an escaped inmate. And that's what we have here. We had an inmate that they were going to try and shackle while he was in his cell. They do that by opening the food flap. We've all seen enough movies. They open up the food flap, you stick your hands through, they get the cuffs on you. Alex Rios was not going to do that. He was not complying, so they opened up the cell door to go in and detain him, restrain him. They said for his own safety, that he was acting erratically. And as they did that, he took off running. And so the question is, as a corrections officer, what amount of reasonable force is he allowed to use? He is protected by the law in some fashion. You have an inmate that escaped their cell. So the question is now for the judge to decide. It did sort of sound, I mean, normally the judge can weigh this and then say, but ultimately let's make the jury decide. And I think he was leaning that direction. And even when the jury came back in the room, he has to be careful what he says. He can't tell the jury that this is what he's thinking about and this is where we're at. Because if you tell the jury, I have to go home tonight as the judge in this case and decide whether the whole thing should be thrown out, and then you come back to court tomorrow and say, oh, well, we're going to continue with the trial, that shows that the judge is leaning that, no, that's not an acceptable argument, and you would influence the jury. You would bias them with the judge's opinion. So that's why he was not allowed to explain to the jury why they are being sent home at 1 o'clock in the afternoon. And this will resume. There was talk, you may have heard, of can they get this done by 3:45? Can we get back on the record so that we can start again at 9 in the morning? And then you heard the judge say that the judge told the jury, hey, we're very close to getting you this case. It may even be given to you tomorrow. You heard the judge say the defense may or may not call witnesses, their own witnesses. So it'll be interesting, but the judge said we're close. He even thinks that they're going to give the case to the jury tomorrow. That tells me that the defense does not have a lengthy list of witnesses, may not have a list at all of who they're going to call tomorrow, but if they do, it would be a short list. So yet another twist and turn in this very, very complicated case against former Richland County Sheriff's Department Corrections Officer Mark Cooper. And so we will pick up again. It sounded like the judge will have the attorneys come in at 8:30. Whether we go on the record at 8:30, we will be ready to continue our gavel-to-gavel coverage. They may reconvene at 8:30. The judge may give his opinion on the request for dismissal. And if the trial continues, which the judge kind of made it sound like it would have to be a very convincing argument, and he cited the 2015 Ohio Supreme Court case and said, look, even those Supreme Court justices were back and forth, some agreeing, some dissenting opinions on what is an appropriate use of force. And then you heard the prosecutor right there at the end asking the judge, sort of giving his last chance, last-ditch effort before the judge went home for the day, saying, if, Judge, I just want you to consider, if force is necessary, it has to be reasonable. And where the judge falls on that is really the crux of what will happen if this case moves forward or not. We will commit, we have committed to gavel coverage. We will be back with you probably right around 8:30 tomorrow morning as the judge gives his opinion on whether or not to throw out this case. Until then, I'm Dan DeRose with 19 News. Have a great afternoon.
19 News is everywhere. Download our CTV.
We go with the yeah. Man, I'll tell you, boy. I'll tell you. This is crazy. Gavel coverage, huh? Here's the thing, right? I heard him talk all about the they keep talking about this officers have certain rights to defend and all that. Yeah, I get it. Yeah, absolutely, they do. Here's where the problem comes. And again, I repeat, there's a problem here. The problem here is that they're not taking into account they had already put him in the suit. They had already deemed him a problem. I'm sorry, not a problem. A threat to himself. And whatever. I get that they had to take action when he busted out the cell. I get it. Lethal force was not on the menu. Not for this one. People want to go on and on, man, and say like, oh, yeah, well, you know, da-da-da. Look at this, man. Look at this. He leaves behind his whole family. A whole family. I'm not going to get into specifics and details. I mean, he really did have a good family, regardless of whether the dude was screwing up in life or whatever. Yeah, maybe he ate a sack of whatever in the cell. But like I said, they should have had him in a dry cell. Somewhere where he wouldn't have got hurt if he climbed up onto something, if he was such a risk, right? This was not, deadly force was not on the menu. Not on the menu for this. This could have been handled so differently. They got caught up in the moment. They felt like, oh man, he got the drop on me, and I get it. He could have got a hold of something within that office, I guess. Scissors or something, I don't know. God only knows what they're allowed to have back there and what they do have back there. Anybody think of that? Were they afraid of what he might have found? I don't know. What I do know, he didn't have to go out in that manner. He did not have to go out in that manner. Totally uncalled for. And just wrong. Just wrong. Totally uncalled for. And we'll see tomorrow morning what happens. Where they're going to pick this up, what they're going to do. Who knows, man? Who knows? Sad. Sad. That's that. And you ain't gotta like it. You ain't gotta like it out of you. I don't want everybody to just agree with me. Nah. I don't want people to disagree with me. I want people to have their own opinions. Let's debate on it. Please hit the like, the subscribe. Take care of yourself and take care of each other. Till tomorrow morning. See you then. What a day. What a day. God bless all the best. South Philly Hillbilly. Gown.